Good morning everyone. This is Professor Dr. M.R.K. Prasad, VM Silgaonkar College of Law, Panaji, Goa. Today we will be looking at clinical legal education, law schools and legal aid. The structure for today's presentation: first we will be discussing what do we mean by access to justice, and after that how the legal education in India is going to help in achieving the access to justice. There we would be discussing on the structure of Indian legal education, and then thereafter we will look into clinical legal education. What are the goals of this clinical legal education? Thereafter we will be looking at how this clinical legal education in India has emerged, developed, and we would also look into the clinical legal education's role in providing access to justice. Thereafter we would see what are the challenges that we are going to face, and also we would be focusing on opportunities that we have in providing legal aid to the poor through clinical legal education. So let us look into the first concept, what is access to justice. We look at the constitutional goals starting with the preamble. The preamble tells us that the Constitution wanted to provide justice, liberty and equality to its citizens. So these reflections of the preamble were well captured under Article 14, 21, 22 and 39 and some other articles. Article 14 talks about equality before law and equal protection of the laws. So therefore, under Article 14, the state shall not deny any person equality before law, which includes an equal opportunity to access to justice for whose rights are violated. And similarly, Article 21, which talks about no person shall be deprived of his life and liberty except according to the procedure established by law, due to the Supreme Court's interpretation in Maneka Gandhi case, such a procedure must be just, fair and reasonable. Therefore, any person whose rights are violated should have an equal opportunity for access to justice. If it is not so, such a procedure would amount to unjust, unfair and would violate Article 21. Similarly, Article 22 clause 1 specifically provides a right to counsel of his own choice in case a person is arrested. However, if a person could not be able to afford to appoint a lawyer of his choice, then it becomes a fundamental right for the arrested persons to claim free legal aid under Article 21, as without lawyer the procedure established by law would not be fulfilled. Similarly, by 42nd Amendment under Directive Principles of State Policy, Article 39A was inserted, which now specifically says that free legal aid is the duty of the state. Similarly, in addition to the constitutional protection, there are several statutory protections for the purpose of providing access to justice. To start with the Civil Procedure Code, Order 33, where in a civil suit, if a person is unable to defend himself, the state has to provide free legal aid. In similar lines, the Criminal Procedure Code, Section 304, also provides free legal aid to the persons who cannot afford a lawyer. And even the Advocates Act 1961, Section 9A talks about the legal aid, and it is not only the state's obligation, but also it is a professional obligation for the lawyers to provide legal aid under Bar Council of India Rules 1995. Rule 46 clearly says that the lawyer cannot refuse to defend a client only because the client will not be in a position to pay. However, the Rule 46 says within the economic capacity of the lawyer, it is the duty of the lawyer to provide free legal aid. But in 1987, finally, the central government has passed a comprehensive legislation for providing free legal aid, the Legal Service Authorities Act 1987, under which the Section 12 prescribes the categories of persons who are entitled for legal aid. So therefore, under Legal Service Authorities Act, once a person is covered under Article 12, it becomes a statutory right to claim free legal aid, and it's not only providing legal aid under the Legal Service Authority, also provides 3-tier system to provide such a protection at district level, at the state level, and at the national level. So, these are the 3 authorities created for the purpose of providing legal aid to the disabled persons under section 12. However, providing legal aid, though it was given to the state responsibility, by looking at the sheer number of the people who are entitled for legal aid under section 12 of the Legal Service Authorities Act, it is imperative to see how legal education in India could step in to fulfill that obligation. So, for that, first we need to understand and assess the status of legal education in India. Legal education in India is imparted by different colleges. There are law schools which are completely funded and managed by the government, and there are university law colleges. Though the funding is received from the government, they are controlled and managed by the universities, and there are private institutions managed by the private but financially aided by the government. There are private managed colleges where the management and finance both looked after by the private people. Then there are private universities which are again managed and financed by the private, and lastly the national law schools. Again, national law schools were established specifically to impart 5 years legal education. Again, they receive funding from the government and also they raise their own funds. So, these are the various schools that offer legal aid, legal education in India. And this legal education in India is controlled by several agencies. However, the legal education is predominantly controlled by the Bar Council of India. The Bar Council of India looks into the curriculum and also the minimum infrastructural facilities that the law schools should have, and Bar Council of India under the Advocates Act was given power to look into the legal education. Therefore, Bar Council has come up with their own rules and regulations regarding recognition of the law colleges. Unless the Bar Council recognizes, the students who are obtaining degrees from these law schools cannot practice in court of law. In that sense, Bar Council of India has a larger control on administration of law schools in India. The second body that could monitor the law colleges is the University Grants Commission. The Bar Council prescribes the curriculum, but usually the University Grants Commission, which gives the detailed syllabus of curriculum, and also they monitor the service conditions of the teachers and teaching hours, etc. In addition to University Grant Commission, the colleges which are affiliated to a university, the affiliating university also imposes restrictions on appointment, service conditions of the teachers and standards of legal education. In addition to that, the state government, in case of giving funding, etc., also imposes certain restrictions and also monitors it. In case of private managed colleges, in addition to all these 4 agencies, even the private management would also monitor and also control the legal education. So, therefore, there is a multiple players controls the legal education in India, often sometimes causes confusion and conflict of monitoring. The structure of the legal education, if you look at in India, is basically started in the beginning with 2 years for LLB course. However, after Advocates Act was passed by the central government, after establishing of Bar Council of India, the Bar Council of India brought a uniformity throughout the country by bringing into 3 years. So, the 3 years course could be pursued by the students after completing any graduation. However, the Bar Council of India felt that the 5 years course would have been better than 3 years course in the lines of engineering and medicine to create more professionalism among the students. A 5 years course was introduced, and the 5 years course was termed as 5 years integrated course. It becomes integrated course in the sense that not only the law subjects, but also the subjects like sociology, history, political science, economics were also taught during the LLB program. However, this 5 years LLB program could be joined by any student after default standard. However, in 2008, further reforms were brought into the legal education by the Bar Council of India. In 2008, a 5-year double degree integrated course was introduced. The idea of 5 years double degree integrated course is, after completion of the 5 years, the students would get 2 degrees. For example, they may pursue their LLB degree in a BA LLB, where they get both BA as well as LLB after completion of 5 years. Similarly, they have BBA LLB, they have BCom LLB, they have BSc LLB. It all depends upon the institution which course they can introduce and they can offer. So, the advantage of this course is that a student who join in 5 years LLB course, after the completion of 5 years, they will get 2 degrees, whereas if you do graduation and come to the law, then you need 1 more year, that is 6 years. So, the advantage of 5 years double degree program is 1 year leewage was given to the students. Now, in India, they have more than 1100 law colleges, and probably every year more than 1 lakh students graduating and joining in the bar. And in terms of registration to the Bar Council, India is the largest country where have largest number of lawyers registered. So, therefore, the legal education in India is a very important stakeholder in promoting and providing access to justice. Hence, if it is going to play such an important role, what should be the goal of this legal education? Unfortunately, there is no such attempt was made by anyone to define or to identify what are the goals of legal education, because unless the goals were identified, the imparting of the legal education has no meaning. Once you determine what are the goals, the legal education need to be designed to reach or achieve those goals. However, Professor Madhav Menon, who is a legal luminary in this country, has identified certain goals for a legal education, which we would just browse through them. The first goal that the legal education should have, according to Professor Menon, is that the legal education should direct and moderate the social change. So, the legal education not necessarily just to become a lawyer, but the persons who are graduating from the from the law schools should direct and moderate the social change, and such a goal becomes important by looking at the fact that the Indian independence movement was virtually led by the lawyers, and he also suggests that the legal education should manifest higher moral values, which is very much in need, and also he focuses on that the degree of competence and discipline that the legal education should provide to the lawyers. And furthermore, very important aspect, particularly in terms of access to justice, is that he says that the legal education must ensure that no section of the society is denied of access to its services because of poverty or a social status. So, this is the most important goal, that the legal education should ensure free and affordable services. And further he goes on and says that the legal education is also to influence the governmental policies towards providing social justice, and also it should increase efficiency and promote excellence.